Hello everybody. Good evening. I'm just double checking on my lights here, everyone. Let me go ahead and get my extra light on. There we go. Hello, welcome. Good evening. Yes, hello. Good to see you all. Welcome. We are back again. It seems like we were just here yesterday. Oh my goodness. Hello. Good to see you. Welcome. Yes. Hello, Frank. Hello. Oh, good to see everybody. Welcome. Yes. Oh, I'm glad. I'm glad your notifications worked. Love to hear it. Let me make sure here I'm in frame okay. I'm in a little different location again tonight, so trying to make sure everything is in frame. Okay, so yes, hello. It's midnight. Hello, Deborah. Good to see you. Welcome. Hi, Lisa. Yes. Oh my goodness. Yes. Oh, yours worked too, Greg. Oh, I'm so glad to hear it. That's fantastic. Yes, just came on, so it's nice that this worked out for everyone's notifications. Yes, story time tonight. Yes, I've got a little bit of a bonus to share with everyone tonight. So another wild Saturday. Yes, we're wild and crazy here. Oh, yes, yeah. My mood ring's just getting started tonight, everybody. Just getting started. I think we're gonna have a good time. I've got lots of interesting things to to share with everybody tonight. So yes, well, welcome everybody. Good to see you. Yes, happy Saturday. Hopefully everyone's Saturday has gone well for everyone. Well, hello, welcome. Good to see you. Yes, so tonight I'm hoping to update you on the Florida situation. So the Florida case will be tonight's topic, but I have a bonus second topic based off of last night's live when we talked about the Nixon v. Fitzgerald case, which kind of drive me a little bonkers. So tonight I've got a little bit of bonus information for you about that case. Oh, I know. Oh, Israel. I know. It's heartbreaking. Yes, the mood ring's back tonight. Yes, I do have a bit of a bonus. Caramel apple pops. Oh my gosh, I love it. Oh, that's fantastic. Oh, I'm jealous now. I'm super jealous. Oh my gosh. Yes. Oh, hello, VC. Always good to see you. Always good. Yes. I've got a bonus. So I will start by reminding everybody about the Florida case, and then I just want to review. My plan is to just review the docket with you to let you know what the status is, because we've had a couple of things going on here with this judge. It's a little bit wonky, but then I do have a bonus to go through for tonight. So, yes, so I'll give you a little sneak peek. I've had this case for a while now, but I've been a little hesitant to share it because the content is, it's a little bit distressing, but I thought it was the best way to illustrate what I was talking about last night with the Nixon v. Fitzgerald case. So I just started, Robin. I just came on. Yes. So tonight I'll take everybody through the Florida case, but then here's the bonus. Are you all remembering that there are lawsuits pending against Mr. Trump regarding the January 6th damages that were done to some people, to police officers? I'm not sure if you remember that or not, but we do have an ongoing, well, hello to you, Generation. It's good to see you. We do have an ongoing case, and I have it right here. I've been hesitant to show it, again, because the content is a little bit disturbing, but this will be our bonus for tonight. We have the DC Capitol Police and the people harmed on January 6th did sue Donald Trump for damages. And that suit is ongoing. It's still going. Now, the reason I want to share it with you is because the analysis in the DC court, the Court of Appeals, goes through this exact analysis. So he used the exact same defense in this case, these lawsuits against him for damages, and the courts already ruled on it. So I thought I'll show you a clip of this. We'll go through this a little bit, and then I can set out the constitutional law principles a bit better. Yes. So we will go through this after the Florida case, but I don't think people may remember that there are still all these civil suits regarding the damages that were done on January 6th, and those are still pending. The last order came in March of this year, again, allowing for the lawsuit to continue. So this has kind of been in the background. It's been going since January 6th. The damage was done there. So this one's continuing on, but it's got a great analysis of the Fitzgerald case. So we'll go through that in a little bit. Should be very interesting. Hi from Ireland. Well, hello, welcome everybody. Yes, good to see you. Hi Daisy, welcome. Yes, so I'll go ahead and get us started then with what's going on with the Florida case. I'll do a little summary here again and then take you through the filings. So this is the case where we have Judge Cannon who is presiding over the case, and there have been some questions about whether or not, she's an appropriate judge or not. And, before I've said I don't really feel like she's done anything yet that would be suspicious. But let me take you through some of these filings here in Florida and then kind of poll everybody and see how you're all feeling about it. Yes. Not billable hours. Yep. Nope. Not billable hours. Oh, my goodness. All right, so are you a lecturer? Yes, I'm not this semester, but yes, I have in the past, will in the future. So that's something I really enjoy doing. So, right. So that presidential immunity question, we will get into that after the Florida case, and we'll go through what the court has actually held regarding that. So, all right, well, let's review everybody. Am I in frame okay? Just double checking. Again, I'm in a little different format tonight, so I'm just wanting to make sure. Am I crooked? I look like I'm a little bit crooked, but on one screen, but on my other screen, I'm looking normal. So, okay, I'm good. Okay, looks good. Excellent. Thank you. Okay, excellent. So, okay, very good as a teacher. Oh, thank you. That's so sweet of you to say. I appreciate that. All right, so let me grab my clicky pen here. So I will just do an overview of the indictment out of Florida, and then I'll take you through the docket in what's been the most recent filings, okay? Post-it note. Yes, thank you for the reminder. Oh, I appreciate that. All right, so let me write down here. We have the U.S. v. Florida case, and it's also known as the classified documents case. So I'll just label it classified documents case, just to kind of give everyone a heads up. So, all right, here we go. Yes, make sure everybody, when you're being sarcastic, you use your sarcasm emoji, okay? Because sometimes our sarcasm gets a little bit... Love your case explanations. Oh, thank you. Yes, I will try to take you through here. So this is the Florida case. We've got multiple different sections being charged. All right, and these are all again the having classified documents, not having them in the proper place they're supposed to be without having authorization. So this indictment that you're looking at, this is the superseding indictment, which was filed July 27th. The original one was filed June 8th, but the superseding one added Carlos de Oliveira along with this section of the code and one more count regarding another classified document. So that's what makes the superseding indictment different from the original indictment. So we are a spicy group. Yes, we love it. All right, so Here we have the general allegations that were set out. Again, I'll just kind of walk you through what's going on here. They're talking about how when he departed the White House, he took tons of boxes with him, and there were classified documents. And we had camera footage, we had boxes, pictures of the boxes everywhere. Everyone, I think, is pretty familiar with kind of how this went down. But in Mar-a-Lago, they had subpoenas, they went in on search warrants, all kinds of information was found and then charged. Really, the key to this case are the terms top secret, which is set out secret and confidential. So these records that were classified like that needed to have a special place where they were to be located. These documents are property of the United States of America, not property of any particular person, and were supposed to be given to the National Archives, and they were not. So the National Archives had asked for them, and they were denied, and then they went forward and did an investigation. So during that investigation, they discovered tons of different documents that were involved, and from all of these different agencies. So some of the agencies involved, we've got CIA records, Department of Defense, National Security Agency, National Geospatial Intelligence Agency, National Reconnaissance Office, Department of Energy. So we have quite a few different departments involved, and the Department of State and Bureau Intelligence and Research. So this just shows, again, these are where the documents are from. We all know we'll have people from all these different departments testifying about these different documents. So they set out too the public statements that he had made multiple times regarding the documents. Then we get into the pictures. So again, here's just an overview of this case to remind everybody that of what's going on. So we've got pictures of boxes of classified documents and various other things on a stage in a ballroom in Mar-a-Lago. Here we have discussions between employee 1 and employee 2. So we've got multiple other people involved, even though there's only 3 defendants actually charged here. This is a very famous picture of the bathroom in Mar-a-Lago and all of the classified documents that have been stacked up in here. And what they were able to determine were that there were specific documents throughout the boxes. So there was a whole bunch of stuff mixed in there. So that was concerning. That was very concerning. Again, we have more pictures here of these boxes containing different documents. Now remember too, we've got all of the counts. Each count is 1 document. So they only charged 32 documents, even though they found over 100 different documents. So this is a picture of a spilled box that has redacted information on it. So we're not seeing anything here we shouldn't see, but this is a spilled box, again, that has classified documents put in there as well. So, a huge issue was he had shown a couple of documents to people. That was added in to the superseding indictment. Military plans were included in there, which, of course, there's problems. There's this discussion back and forth where he's saying he should have declassified it, but he can't now. And so recognizing, again, the intent that's involved with that. So more about the cardboard boxes, more pictures of all of these boxes. Again, remember, the National Archives had asked to go through the boxes, had asked to have them back, and he had said no. That's why a search warrant had to be involved. So now we have Nada, who was his valet, or still is his valet, was part of the indictment because he helped to move the boxes around. They were able to get security camera footage along with a bunch of other stuff in order to place each box and each document in the box, and then where the box was located and where the box was moved around. So we have this chain of custody for all of these documents he's been charged with. So that's all set out again in this indictment. So I'm just kind of taking you through just to remind you here of what happened. We had, again, Mr. Nada coming in and moving some boxes around. We also had a certificate that had been filed saying, or that had been signed saying all of the information has been given over, and that was incorrect. So we've got false statements to the FBI as well. We also had one of his attorneys that noticed a whole bunch of classified documents and realized it, put it into a folder to separate the documents to keep them safe until that attorney could put them into the proper custody. So one of the big issues and why Mr. De Oliveira was added to the indictment, the superseding indictment, was because he had been talking about the security camera footage. So he was involved in that. I think many of you probably have heard that the IT guy involved in this case here, where they go into his discussion with the IT guy, has decided to testify for the government. So he is now testifying on behalf of the government regarding the different conversations he had with De Oliveira and what was requested of him regarding the classified documents and the tapes. So there was this question about whether or not he could erase the tapes. So he'll be testifying to that. So that takes us then to an overview of the documents that they found. So I think this page is really important. In Trump's office, they found 27 documents, and then these are the 3 categories. Now, the categories of classifications were set out in an executive order. That's how the law is written. So they had 27 in his office. They had 75 in the storage room. So, there were a lot. So after that, what they put together were the counts. So I'll take you through counts 1 through 32. Now, this one is with regards to Donald Trump himself. So each one of these documents that they're talking about, they've charged 1 count. So that's why it's 32 counts, because they have 32 documents. They found more than that, but that's all that they charged. Okay, so for each count, they listed the date of the document and what the label was on it. So each one of these counts is its own document that they will prove at trial. What are the consequences for giving false statements to the FBI? Well, if you're lying to the FBI, you can get charged with providing false information. I believe it's actually a Class D felony, so I think it's 5 years. There's no minimum involved, but yeah, you can get charged with a felony for that. And they were told that too. So here's again another picture of the different documents, just to give you an idea how they put it. So like count number 10, this document's dated November of 2017 concerning military capabilities of a foreign country. All right, so what's really going on in this case right now is this fight between Jack Smith and the defense, because Jack Smith has these documents and they have to follow protocol in order to see them. So the defendants have said, well, we want to see all of these documents for each of these counts. And the government has said there's a protocol that we have to follow under the law. So right now, the big issue is getting these documents to the defendant. Now, the government has argued we can redact or we can summarize, but some of these documents you shouldn't be allowed to see because it's not safe. Again, because of the protections set out under the law for these documents, they're protected. So there is kind of this ongoing fight between, show us the documents, don't show us the documents. Another problem with these documents has been that the government's been trying to show some of these documents, but the judge has been dragging her feet. That's going to be a common problem with this judge, and you'll see it when we go through the docket. They were ready to start going through the process in June. She finally approved the protective order in September. So they could not even give some of these documents to the defendant until after she approved the protective order, which was, weeks and weeks and weeks after they had wanted to try to do it. So we have some problems with this judge. We've got some timing issues going on. It's becoming a problem. It really is at this point. It's becoming pretty obvious that everything is being pushed back with this judge, even though really technically the details and the facts and the proof for this case is very simple. Was the document labeled? Yes. Did he have it? Yes. Did he have authorization? No. That's really it. But there are a lot of protocols we have to go through because they're classified documents, extra special hearings and so on, and even viewing them in secured locations. And so the judge is dragging her feet. We're having a bit of a problem. Yeah, Cannon, it's becoming pretty obvious at this point. Now, again, I started by saying she had not done anything that had raised any suspicions, but I'm at a point now with the new orders that just came out on Friday or yesterday, where I'm starting to feel a little suspicious about her. So at this point, and I think other people may be too. Again, I'm not saying she's not being impartial. I'm just saying it seems as though she's really dragging her feet without a legitimate reason. So I'll kind of get into that a little bit more as we go. So we've got counts 1 through 32 were 32 separate documents. Count 33 is conspiracy to obstruct justice. All three of them were charged with that. They had a conspiracy involved, false misleading statements to the FBI, and so on. Count 34 is withholding a document or a record. So under the United States Code, you cannot withhold that document when asked, and they did. And so they were charged with a violation of that section of the code. See, it's a pretty open and shut situation. Corruptly concealing a document or record, that was count 35. Count 36 is concealing a document in a federal investigation. So we've got the original defendants as well. If she continues, can anything be done about her behavior? Jessica, not at this point. Not at this point, and I'll take you through that, but it's a bit distressing. It's becoming distressing now that her order has come out on Friday or yesterday. It's becoming pretty obvious that things are taking more time than what they really need to take. So I'll take you through her order. I'm not sure what can be done. I feel like Jack's doing everything he possibly can to try to keep things going and to keep this on track, but there's only so much he can do. The judge runs her courtroom. It's her show. So if she wants to continue, if she wants to push things further on or allow things time-wise to be done later, that's up to her. It's going to be really difficult to appeal those kinds of things. So could she be going slow due to the precedent this will cause? It's possible. It's possible. I do not know why. I cannot, there's different ways. Lots of people have theories about it, but personally, I do not know why she's dragging her feet at this point. But it's becoming clear that she is, though, and that's a bit distressing. I keep thinking, too, like maybe her docket's just really full, but then I'm not sure that that's legitimate. Because if you take a look at Georgia, that docket is so packed, yet the judge is like, let's get her done. So, I don't know. It's distressing for sure. Have you ever seen a judge behave this way? New judges can do this. If she's hesitant to move forward because she wants to make sure everything's perfect, that could definitely be a motivation. Or she's really not sure what to do, or, maybe she's just got a ton of cases. But I don't know. I don't know yet. I'm undecided. 38, we've got false statements and representations, and that was charged for Trump here. And then we've got, again, just taking you through what the counts are. We've got Walty Nada, false statements and representations for count 39. Here we have this conversation between law enforcement and Nada, where he says he doesn't know anything about any of the boxes, and that's been proven to be false based off of video and various things. So we've got count 40 included in the superseding. That includes Carlos de Oliveira, which has to do with altering, destroying, mutilating, or concealing an object. So this is the security footage discussion that went on that a lot of people have probably heard about now. Count 41 is also new regarding corruptly altering, destroying, mutilating, and concealing a document as well. So they all three were charged with that new count in the superseding. False statements and representations with Mr. de Oliveira, who is, was added as the third defendant as well. So another statement that he made showing he knew more information than what he let on. So again, just to give you an overview at the very end of what the counts are, for Donald Trump, we've got willful retention of national defense information. Those are counts 1 through 32, up to 10 years, no minimum. Count 33, the conspiracy, is up to 20 years. 34, withholding a document or record, is up to 20 years. 35, concealing a document, up to 20. 36 is concealing a document in a federal investigation, again, up to 20 years in prison for that. Count 37 is a scheme to conceal, so up to 5 years. Count 38, false statements and representations. So this is that false information to the FBI. So that comes out to a 5-year maximum on that one. Count 40, altering, destroying, mutilating. So this is that security footage again. That's up to 20 years. Count 41, altering, destroying, mutilating again is also up to 20 years. So that was for Mr. Trump. Then Mr. Nauta was charged with separate counts. He was not charged with counts 1 through 32 regarding the documents. He was charged with the conspiracy and withholding pieces. So he's got count 33 for up to 20, 34 for up to 20, 35 is up to 20, 36 also up to 20. The scheme to conceal is 5, false statements is 5. And then the 2 security footage ones are up to 20. So that's Mr. Nauta's counts here. And then lastly, we've got Carlos de Oliveira, who was the 3rd defendant added on. We've got conspiracy to obstruct, which is up to 20, destroying up to 20, destroying again up to 20, and then false statements is up to 5. So that's some pretty significant prison time. Like, people aren't really talking about that much with the Florida case, because I don't think people realize the sheer quantity involved. I mean, just counts 1 through 32 that are looking at all of that time together. I mean, that's hundreds of time. Can the prosecution request a new judge? Well, you have to have a basis for it. Now, a judge, changing the timing on things, that alone is not going to be enough in order for them to have grounds to ask the judge to recuse herself. As you know, with all of the other cases, Trump has asked all of the judges to recuse themselves. None of them have. I suppose technically Jack could ask that too if he felt that there were proper grounds. I'm not sure we're at that level yet, but it is getting to be a little bit questionable. Where to get the grand jury from? Well, it's DC. Yeah, so it's all DC. Political prosecution. Yeah, no, I mean, if you have documents you're not supposed to have, that's just a legal thing. All right, so a couple things. Let me take you through a couple things that I think are important to know, and then I'll take you through the docket. So I'm not going to put a sticky note on this one because I'm just going to show you a couple pieces of the Classified Information Procedures Act. So when I take you through this docket, anytime I'm talking about SIPA, there's special hearings for SIPA. So I just want to explain what this is. This is a section of the United States Code, and it says, what do we do when people need to see classified documents? What do we do? So we have to have special hearings. We have to have special protocols. Particularly right now in Florida, we've got Section 3. We have a protective order for those 32 documents, right, that we've been talking about. And then Section 4 is the other piece that we're talking about a lot, which is discovery of classified information by defendants. So it's literally written into the law what a defendant in a case like this has a right to and what the government has a right to regarding classified documents. So we have an entire law just written about how to prosecute classified documents. All right, so keep that in mind as we go through this. That there is a protocol here. This isn't just, what are we going to do? Like, it's actually written by Congress in law. So it's pretty clear about that. So let me take you through the Florida docket and show you what's been going on here. Let me just make sure I'm in frame here. I've got, again, a little bit different format I'm trying out. There we go. Yes, so here is the docket. Again, you can pull this up yourself online, US v. Trump, and then this is the case file number. You can go through and see it for yourself. Now, what I've done just to keep everything straight here is anything highlighted in green is the government. Pink is the court, and then orange is defendants. So when you see those colors, that's what they mean. So I'll give you an overview again here of this docket to show you what's been going on. We started off with the motion to seal June 8th. This was with regards to the indictment. The original indictment came down by a grand jury then and was seen by the public then June 8th. That's the original date. What about yellow? That's just the indictment. There's only 2 yellows, one for each indictment. So, sorry, one more color. Purple are any of the motions to intervene. So the press has asked multiple times to be able to come in and see the documents, to be part of the proceeding and the court. And they've done that for all of the cases. And the court has said yes and no. So depending on how it went down. So we've got here, we're starting June 9th, unsealing the case by the court. We have an order on the press coalition motions. The magistrate judge kind of allowed for the press situation to happen. We've got a notice of attorney appearance. This is the first filing from Donald Trump. Next, we've got a motion to appear pro hoc vice. You'll see this a lot, these purple motions. And this, again, is just someone coming in and saying, hey, I don't work in Florida, but I'm an upstanding member of the bar, and I would appreciate it if I could be involved in this case. Sticky? Yes. Yes, thank you for reminding me, especially because I just have it right here next to my hand. There we go. So we have that first notice of appearance. We have our pro hoc vice here. We've got paperless order. That takes us then through minute order proceedings. Again, this is just some of our technical pieces when we're starting. We've got the personal recognizance bond that was involved at the very beginning as well. So again, I'm just kind of taking you through what's been going on. We've got notice of compliance when it comes to the, because we have an arrest that's coming up. We also have a notice of attorney appearance for the government. So we've got Edelstein here. We've got another one from the government. We've got responses involved there. We have another notice here, Gilbert, a paperless order regarding that, another appearance of Harbach, and then an order granting an unopposed motion for a protective order. So again, the protective orders, we've got to have a lot of protections put into place because of the sensitive nature of the documents. So the first really significant order that came down by Judge Cannon was the omnibus order. And in this order, she set out the timeline for the entire case. So, where did you get the sticky holder? Oh, it's just a magnetic frame, you know, that you put a picture in. But because the back is smooth, it's easy to kind of move it around. So, all right, so let me get out the omnibus order. Do the orders that are paperless issued by, right? Well, you know, sometimes I wonder. Technically, I suppose they could be. They could be. Okay, no, it's okay. I'm just getting started. So just so everyone knows, this is the original order that was set out. This is the omnibus schedule that she set out, all right? So she set out when we had those Section 3 motions that I just showed you in the statute. So the discovery motions, when those were due, when the hearings were doing, initial production of classified discovery, when those things were doing. What's happening right now is this kind of mess in this area because the defendants are asking for a continuance. They're asking to push these dates back further because they're saying they haven't had access to the documents. Meanwhile, the documents were made available way back up in here, but the judge didn't issue a protective order until around this period of time. All right. So all of this time has passed where they could not give the defendant the documents because the judge hadn't issued a protective order yet. So she was kind of out of, that's the first sign that she was kind of dragging her feet a little bit. Yes. So, yeah, and again, this is just this first set of her omnibus order. Now, if we flip it, we have the rest of her schedule set out. We have a couple more deadlines than in October. We've got November deadlines regarding different disclosures and motions. Status conferences right after Thanksgiving. Hearing on pretrial motions is December 11th. So she technically at the very beginning set out a pretty good schedule. It was a pretty, tight schedule. I mean, it was generous. It was doable. So the SIPA hearing was set for January 16th, and then we've got more hearings set in here. Again, we have to have special hearings because of the documents. And then the jury trial itself is set for May 20th. All right. So what we'll be talking about is how they're asking for continuances to move everything. So if they move one thing, everything would get pushed back. So that's really what the issue is here, is whether or not the judge will stick to the schedule that she originally set out in her order. All right. So she set that order on June 20th. And that takes us in through a few more orders that happened. We've got discovery here. So we've got first response. This is where the government said, okay, we've got documents to show you. We need our protective order, and then we can show the documents to you. So that's when that first came down in June. We have a motion for a hearing here, motion for bond. We have a motion to continue. Attorney updates, orders here. I'm skipping through because these attorney updates are just new people coming in and moving around. We have more pro hoc vice and intervening questions involved as well. So that just means we have attorneys for like Politico and various other news organizations that want access to the documents. That's what that is. So it's not really anything of any importance. Can the information on these documents have weight on to how much time he's looking at? No. Each document itself is one charge. So it doesn't matter the level of classification on it. It's all the same charge. So the charge that he set out, sorry, that's not good sound. Here's the charge. Willful retention of national defense information. It doesn't matter if it was extremely classified or not extremely classified, which level of the three it was, as long as it was willful retention of information of one of the classifications. That's what he was charged with at 10 years each. Yep, that's a really good question. All right, so we've got more pro hoc vice going on, paperless orders as well. So again, I'm kind of skipping through because that's not really that important. Now we have a second response coming in from the government saying, hey, we've got documents to show you, but we need our protective order. Judge, please, can we have that? At this point, the judge has not granted that. So we've got some paperless orders here going on, but nothing in those orders setting out a protective order for the classified documents, which is what's required by statute under the SIPA statute. All right, so they have to have that in order to see that. We've got replies and so on. We have a protective order as well being worked on, supplemental responses. Again, I'm just kind of skipping you through here until we get to something a bit more current. So here we've got the next major piece, which was the superseding indictment. So July 27th is when De Oliveira was added to the indictment, along with the security camera footage that was added July 27th. So now we start getting into what they call speedy trial reports. So I've printed these out because there are 5 of them, right? Now we know in Georgia they had this, we had this request for speedy trial, which means you have to bring your case within a certain period of time. In this particular case, it's a little bit different because it's a federal speedy trial statute that they're using and because it's classified documents. So here's the first speedy trial report, and you can see we only have 2 defendants on here at this point. So according to local rule 88.5, the court's omnibus order setting the trial date, they have to submit the speedy trial report. Federal grand jury indicted on June 8th. And then here, the filing of pretrial motions automatically stops the speedy trial clock. So what's important with the speedy trial updates is that they're keeping track of the time, because speedy trial is all about the days. It's the same thing as with the statute of limitations out of the New York civil case, right? So what's happened here is, because of how this case is proceeding, which is perfectly normal, they've paused the speedy trial clock so that they don't get into trouble, because no one's waived speedy at this point. Speedy has not been waived. It's been paused, and that's completely normal and fine to do in federal court. So these speedy trial updates are just saying, hey, we're still paused. We're still paused. Where are the documents then? There are no documents for a paperless order. There are none. I know it gets a little suspicious, because the other thing too, if we have a paperless order, we don't have a full-blown document to go through. All we have is this note in the file. That's why it's a paperless order. It's suspicious, isn't it? Yeah, it gets a little bit suspicious. Although I don't know. Maybe they just do that a lot in Florida. I don't see a lot of it going on in DC, I would say, but again, it could be just depending on your jurisdiction. Tells people verbally. Usually it's issued from the bench, so she would just, submit it, and it would just be told. We love the papers. I know. That does seem, Suze, I agree. There's a lot of paperless orders, and some of these paperless orders are like really important. Yeah, I believe in checks and balances too. Is Jack going to have it removed? I don't know that he has grounds at this point. I really don't. All right, so we've got a waiver of personal appearance. So now we're into August. We've got an order striking sealed filings and ordering briefings. So we had briefs that were needing to be put into place. Now, all of these documents at one live or another, I have gone through with you. I don't think I've missed any of them. Again, we have another paperless order denying the motion for permission to bring electronic equipment. We have a response in opposition to the government's motion regarding the protective order pursuant to Section 3. Remember, Section 3 has to do with protecting those classified documents. We have a minute order for proceedings held before the magistrate. So this is the arraignment situation. A waiver of personal appearance came in. Next, we have a supplemental response by the government to the standing discovery order. So the government, I think, is getting a little frustrated because of the discovery. Next, we have another paperless order. On or before August 22nd, all new counsel of record who do not already possess a required security clearance shall initiate and complete all tasks as directed by the Litigation Security Group of the U.S. Department of Justice. Therefore, file a notice of compliance no later than August 23rd. All right, so we have another paperless order. We have a reply to the response to the protective order issue going on. So the government's responding here. Then we have a supplemental response as well. Now we've got an order scheduling the sealed hearing on the SIPA Section 3 protective order. So we've got a hearing that's being scheduled. Next, we have notice of filing set out here. What this particular filing is, which I thought was actually very interesting. So let me share what it is. This was filed by the defendant, and in the exhibits he included his other indictments. So he included the DC indictment and the Georgia indictment, and basically said his schedule was very busy, and so he included that in his filing. Like, what? That's very, very odd. So. All right, we have a supplemental motion for a protective order again. The government's asking for that. We have another speedy trial report. This is the third one. There's a total of 5. Again, just updating the fact that speedy has been paused so the government doesn't run into any statute of limitations issues. Yeah, he's busy. He's busy with his other cases. So yeah, that's a thing. That was part of his... That was part of his discussion on why he needs continuances. All right, we've got another notice of filing by the government, supplemental response here, notice of attorney appearance by the government as well. And then that takes us into another paperless order for the proceedings held before Judge Cannon, a sealed hearing held September 12th. The court heard an argument from the parties on the special counsel's motions for the protective order pursuant to Section 3. So what's happening is the government is trying to get this protective order put into place, right? So they can give them and show them the documents. And the government continues to push. So the judge has not done the order, so they're pushing and pushing and pushing until finally we had a hearing. Order to follow. Total time in the court was 2 hours. Here are the appearances. So that's what happened here. The protective order then was issued pertaining to the classified information disclosed. So this is finally the 13th of September. They finally have a protective order in place so they can show the defendants the documents the defendants are requesting. Now, why this is important is because the defendants are saying because it took so long in order to see the documents, they want a continuance. But the only reason it took so long was because of how the judge set things up. So Jack wasn't very happy about that, and I don't blame him. So we've got an order here following the hearing. Notice again of attorney appearances by the government. A status report. So this was the joint discovery report. And as you remember, I did go through that report with you where the state said this isn't a joint discovery report. It's just us. And the defendants aren't doing it. So that was kind of a funny order. I thought like, oh my gosh, somebody's not helping doing their part of the project. Motion for a revised schedule for motions to compel. So we've got Trump is filing a motion for a continuance. So he's asking for a different schedule. We have a paperless order granting in part special counsel's motion for Garcia hearings. So this was the last major order set out until yesterday. What this is that the government had said a couple of our witnesses are represented by an attorney that's also representing the defendants. And so we think there may be a conflict. We want a hearing on it. So she did set that for a hearing that is set. We've got an opposition by the government regarding this time schedule change. Then we have a Trump responding and saying, I need that. What exactly is a paperless order and why are they requested? A paperless order is just the judge's choice. So typically a paperless order would come into play if there's just not enough time for the judge to write the order. But I don't know if it's protocol in Florida, if that's like just what they do there or not. But this way she's explaining what it is, but she's not having a written out order, which is what we see in almost all of the other cases. Like particularly in Georgia, which is a state case, so it is different. But in Georgia, every single order is written out by the judge. So it's a little bit different. Someone needs to take us. That's a good question. All right. So yeah, that's it with the paperless orders. I'm not exactly sure. Again, it could just be a unique Florida situation, but there are a lot of paperless orders here. Here's a response again in opposition to this continuance request. Now we've got another speedy trial report. This one is the fifth one. We also have another response where the defendant is asking for more time, saying he needs more time. So then that takes us to yesterday. All right. So we have this question about whether or not things are going to be continued so that he can have access to these other documents. Now, Jack wrote, we can tell you what's in the documents. I don't think you need access to them in order to make your defense. Not only that, but the statute says we don't have to show them to you. So Jack had put on his argument. Defense came in and said, well, we want to look at them anyway, so you need to push everything back, at least 8-9 months. So this is what the judge came out with. Another paperless order. Is she slow rolling this on purpose? I don't know, Tony. I don't know. But it's pretty clear that it is slow rolling. It's becoming very clear that she is absolutely dragging her feet. I don't know why. I really don't. But it is becoming very, very suspicious. So her paperless order yesterday is temporarily staying the SIPA 4 deadlines. So she's paused the deadlines that she set out in her order, all right? Pending consideration and resolution of defendant's motion for a revised schedule for motions to compel and SIPA Section 4 litigation. So they are doing a motion to compel because they want to see the documents. The government said we made them available. The judge didn't give us a protection order. She just issued a protection order like 2 weeks ago. You know, we're fine. You don't need a motion to compel. We're fine showing you what we need to show you. Although some of the documents we're not going to show you. We don't have to under the law, and they're saying we want to see them anyway. So she has paused everything and wants to consider this revised schedule. So remember the schedule that she set out where everything had its place and everything was ordered. Now she's contemplating moving that schedule. So she's also waiting then for supplemental briefs on the SIPA Section 3 and 4. So that was her paperless order. Did they find a proper secure room for the documents? They did, but not all of them. Some of the documents, I think there were maybe like 5 or 6 of the documents. I think at this point, they're saying there is no way to make them secure enough. It is just too much of a national security question for the defendants to be able to see them. And that is allowable under the statute. So they're going to be arguing that out. Next, we had, after this paperless order, the supplemental response to the standing discovery order by the government. And I do have a copy of that. And I will share with you that. So that's the government's just filed this yesterday. All right. So we've got all these questions about discovery. We've got all these questions about timing. So the government just filed this. I will take you through what they filed here. So the judge doesn't have to explain herself. You know, the other thing about paperless orders too is I'm not sure, but it seems like it would be harder to appeal, in my opinion. It would be harder to appeal a paperless order that's like 2 sentences long and argue it on an appeal. So even the wording that she has here with temporarily staying the SIPA, because she's just pausing it and not ruling on it. We don't have a ruling, so she's not necessarily able to make you're not necessarily able to appeal it. So I don't think Jack can actually even appeal it. To the right, to the right, to the right. Here we go. Thanks, Greg. So I don't think he can appeal it. So I think that's part of it too. Yep. Thank you, everybody. Yeah, harder to appeal. Yep. Yes, thank you. Is it better now? Let me make sure I'm in frame for this one. Yep. Okay. Yeah. Dark blue background. Oh, good. I'm so glad. Yeah, Deborah, I went in, I had fabric here before, but I noticed it kind of was a little bit wonky on camera. So I went and kind of changed it so that it wouldn't be so, mind numbing. But thanks for telling me. I'm glad you told me. I'm glad it's working out. I'll keep using it then. Yes. So let's get into this. Okay. Non-textured surface. Yeah. Do you think it's intentionally on the judge's part? I don't know. I really don't know. I want to stay open-minded, but I have concerns. I think a lot of people do. I think it's a lot of people have concerns. All right, so let's go through this. So the government filed the government's supplemental response to standing discovery order. All right, that's what it's all about. So Trump is saying, I need more time to review discovery and to compel. The judge said, fine, we'll pause everything until I can go through it. So this is what the government said. The United States of America, by and through the Special Counsel's Office, files this pleading to supplement prior responses, going through these different documents, to the standard discovery order issued June 13th. This pleading complies with Local Rule 8810 and Federal Rule of Criminal Procedure 16. Per the protective order issued in the case, the government has provided 5 prior productions of discovery to defendants, all 3 of them. On October 6th, the government provided a 6th production of unclassified discovery to counsel for defendants. Production 6 consists of less than 1,900 pages and includes inter alia memorialization of recent witness statements and materials recently obtained by the National Archives and Records Administration. So we'll flip here. The government responds to the specific items identified in the standing discovery order as set below. Demand for reciprocal discovery. The United States requests the disclosure and production of those items described and listed in paragraph B of the standing discovery order and as provided by Federal Rule of Criminal Procedure 16B. The government is providing information or material known to the United States that may be favorable to either defendant. This is a Brady rule here on issues of guilt or punishment within the scope of Brady, which they are citing. D, the government has disclosed and will continue to disclose any payments, promises of immunity, leniency, preferential treatment, or other inducements made to prospective government witnesses within the scope of the Giglio case. So this has to do with being able to impeach witnesses on the stand. So this is kind of something special in federal court. The government's discovery production include the grand jury testimony, recordings of witnesses who may testify for the government at the trial in this case. The government will continue to produce on a rolling basis additional unclassified witness material as it is acquired. Aside from that, an additional Jenks material, in particular agent communications. Again, that has to do with impeaching witnesses. The government is not aware of any additional unclassified discovery material subject to production. The government is aware of its continuing duty to disclose newly discovered additional information required by the standing discovery order and these rules here, and the obligation to assure a fair trial. So they're just going through and saying, hey, we know we've got obligations and we're complying with it. And so it's been signed by special counsel. So that's their response. They're saying, hey, we've been giving you buckets of discovery, just so you know, and they're making a record of it. So every time he files a motion explaining what he's doing, he's making a clean record. Can they impeach witnesses on the stand? What does that mean? Oh, sorry. Sure. Okay, so, right, when someone's testifying, we have our own witness. We ask them direct questions. Now, when the other side asks our witness questions, they're trying to discredit them, right, on a cross-examination. So this process of cross-examination in order to discredit a witness, we call that impeaching the witness. And we have special rules of evidence that allow for questions like that. So what this rule here that they're talking about is they're saying if there's information that we could use to show your witness isn't credible, you need to give us that information. You can't keep that information from us under the cases they're citing here. So that's what they're talking about. If there's a credibility issue with any of the witnesses that the government knows of, they need to tell the other side so the other side can use that to impeach or discredit the witness. Okay? Oh, yeah, it is a pretty straightforward criminal case. It really is. It really is pretty straightforward. It really is. It doesn't get much more straightforward than this, other than the New York civil case. All right, does anyone have questions on the Florida case then? That's kind of where we're at right now. We're kind of in a paused situation in Florida. This judge is moving slow. Here's what the schedule looks like. Again, on the 10th was supposed to be that SIPA Section 4 challenges due. But because of the order that just came out yesterday, I don't know when this date's going to be. This date's going to be pushed. I'm not sure when it will be moved to. But then the Garcia hearing, so that conflict of interest hearing, is set for the 12th. But again, I'm not sure when she's going to move these dates to, because again, she's paused it with that paperless order. Hydrate, yes. Thanks for the reminder. Can Jack do anything to move the Florida judge along? I think he's doing everything. He's making a really detailed record. His filings are very detailed, showing every single thing that's going on. And I think that's a huge strategy. It also nudges the judge because she will be reading each one of those. And so it reminds her like, hey, here's this, here's this, here's this. So it's reminding the judge, kind of keeping her in check to some degree, and then creating a record if there's an appealable issue. So I think he's doing a good job of doing that. But I'm not sure what else he could do at this point. I just don't see anything that would rise again to the level of asking her to recuse. I just don't. She may be dragging her heels, but I mean, again, it's her courtroom. She can do that. So at this point, I don't know of anything he could do to push it further, but that could change in the future. Sticky note, yes. Yeah, we were just doing the calendar. Doing the calendar. Oh my gosh. Taking her time with the bologna sandwiches. Yes. Oh, what month? Yes. So this is October. This is the October setting here. Yep. How much would it take to dismiss the judge? They would have to show, I mean, it would take a lot. It would take a lot. And you can look at any of the other cases where the judge has been asked to recuse and they've gone through and explained, like, you have to have a pretty serious conflict in order to be pulled off of a case, especially because she was just randomly chosen too. She was just part of the lottery and was the one chosen. So it's not like there was a special assignment just to her for particular reasons. I mean, it was just her turn to take a case. So it would take a lot. Do you think all the judges are in communication? If so, much to coordinate? I think there is some coordination. I'm just not sure what. You would think the federal judges would be coordinating with each other. And so I get the feeling that Judge Chutkan's like, let's get it done. Because if you look, Judge Chutkan was also looking at a motion to dismiss, which we went over last night. Yikes. And also this continuance. And she moved it was a SIPA 4 hearing continuance also. And she moved it like 3 days and said, okay, fine, but we're set. So, I mean, she just has a very different style than this judge. So I really don't know if they're communicating. I really don't. So thorough. Oh, thank you. I do try. Has he done that to her yet to recuse? To Judge Chutkan, yes. He's also requested the New York judges and prosecutors and judges in Georgia too. So Georgia, New York, and DC, but he has not asked Judge Cannon to recuse yet. Yep. A regular citizen would have had jail time by now. Yeah, you're not wrong. I don't think you're wrong. I certainly wouldn't be doing it. I would like to see her other cases compared. Yeah, I think that's a fair question. I mean, if this is just kind of how she runs her show, then, we're fine. We're good to go, and what is her docket? How does she run things? Because if she's, this is just her style, then it's just her style. Angren needed to be disbarred because he smiled and posed for cameras. Well, he's a jokester. He's a little different. So, I mean, again, he's been on the bench 20 years. That's not even the weirdest thing he's done, He's just a little bit different. That's because he appointed her. Yeah, and that could very well be. But yeah, no, he's not asked her to recuse yet. All right, so that's the update out of Florida. Now, there were some new filings out of Georgia, and I do plan to come on tomorrow to update Georgia, but I don't want to update 2 trials in the same night because I think it would get too confusing. So I have set for my next live to update Georgia tomorrow, but I do have a kind of a special bonus for tonight if people are up for it. I wanted to, last night we were talking about this presidential immunity question, right? So that's been pled in DC and in multiple other cases. Thank you for covering Florida. Oh, absolutely. And I'll be back to cover Florida again. Just to give you an idea here, I will be doing Georgia on Sunday. I have the New York civil trial scheduled for Monday, the New York criminal trial scheduled for Tuesday, and then I'll be back to update Florida on the 12th. So I do have those. Special bonus time. Yes. All right. So let's start talking about that. One of my, I don't know why, I didn't realize this was a trigger for me, but apparently it's a trigger. It's the Nixon v. Fitzgerald case. All right. So this is a presidential immunities case. What time are you coming on in the morning? Yes. So I am planning, I was not able to come on this morning. I just didn't have any voice to come on with, but I do plan to come on tomorrow, and it will probably be 10 o'clock will be the best time for me to work to be able to come on. And so I've got two things I want to go through. Tonight, I want to take you through the bonus here, the Nixon Fitzgerald presidential immunity. But tomorrow morning then, because I will be doing the Georgia update in the evening, but tomorrow morning, I'm going to take you through the lawsuits that were filed against Trump for the DC police officers. All right, so that's what I will be doing in the morning. Before you start, hydrate again. Oh, yes, hydration. So 10 o'clock, yes, 10 o'clock Central Time. So 10 a.m., I'll do kind of a special extra and go through this case. I've had this case for a while, but I have not shared all of the details of it. So I'll take you through the entire case tomorrow. Tonight, I'll take you through the constitutional law questions, but tomorrow I'll actually take you through the case itself. So it's pretty interesting. This case, again, this is the lawsuit regarding the officers who were harmed on January 6th and the lawsuit against Trump because of the harm that was done. Oh, thank you. Yes, no absolute immunity. Right. Exactly. So this is the order that's come down. Now, this case is slow moving. This order came down February of 2022, and it was just this past March where another appellate court, oh my gosh, not the hot dog. We've got an order saying, yes, it can proceed. So we have a green light on this lawsuit. Again, these are the DC officers that were harmed and the people that were harmed during the January 6th insurrection situation. All right. So I will be, this is the ones that have grounds, and the court has held they have grounds. And they go into the details and the findings of fact that they found in order for them to be able to go forward. Now, Donald Jr. has been dismissed from the case. Rudy Giuliani has been dismissed from the case. The Proud Boys were not dismissed from the case, and neither was Donald Trump. So it's very interesting. I'll take you through that tomorrow. I'm going to kind of pull the highlights out. I'm not going to go through every single page. It's just too much. But I'll take you through the most critical facts, and then I think there's really only a couple of really big legal arguments here, so I'll just take you through a couple of them, and then also why Giuliani and Donald Jr. were kicked out of the case. So I'll go into that. So I'll kind of be, I'll be kind of giving you the short version of it, because 112 pages is a bit much. So I'll be doing that in the morning, 10 o'clock Central Time. 10 o'clock Central Time in the morning, I'll go through this. And then in the evening, my normal 6 o'clock Central Time, I will do the update then on Georgia. We do have some new orders out of there. So that's the plan, okay? So, yes, you got it. So let me then take you through the amicus brief. So based off of the case that I was just telling you about, this is the lawsuit against Trump for the harm done to the police officers during the riots on January 6th, or whatever you want to call them. All right, they refer to them as riots. They refer to them as insurrection. There's lots of things. Rally is another term that's being used. So can I buy you some highlighters? Oh, that's so sweet. Actually, look, I've got all my highlighters out. I've gone through 6 yellow highlighters, everybody. I'm so proud of myself. I don't know why. I'm always so proud when I can do that. Oh my gosh. You know, I'm not sure that I don't remember any of my students reminding me to hydrate, but also I had lots of time to pause with the students. They had lots of breaks. Are these civil? Yes, this is a civil lawsuit against Donald Trump. So the reason I wanted to show you this amicus brief, all right, so amicus means friend of the court. Anytime there are really interesting or complicated questions, the court can ask for a specialized brief from experts in the field. So they asked for a brief on this issue of presidential immunity that we were talking about yesterday. So that's what I want to take you through here. So let me put a sticky note on here explaining. This is presidential immunity analysis. All right. So I'm not going to read the whole thing, but I will take you through the legal arguments because they explain it so much better than I explained last night. Yep, right in the sticky note right now. All right, argument. So here we go. My spelling is atrocious. I'll tell you that right now. Just tell you that straight up right now. I apologize. All right. So here we go. We've got, again, this is the amicus brief, and this is for the lawsuit against Trump for the damage, the harm that was done to the people that were harmed during January 6th. So they set out the parties and who the amici is, or amici, however it is. But what they're doing is the rulings under review are the opinion and order entered February 18th of 2022, again, regarding the civil lawsuit. So some of the cases that they're going to talk about will be the Moore case. All of these cases are against Trump, okay? Moore v. Trump, these are all still ongoing. Moore v. Trump, Tavron v. Trump, Kirkland v. Trump, Smith v. Trump, and Garza v. Trump. All of these lawsuits are still going, all right? These all came out of what happened on January 6th. So they're just saying, hey, we've got a whole bunch of cases. So this case is just one of many. Yep. I think, not very many people necessarily even realize that because we have so much going on. We just have so much going on. So yes. How many does he have? I think, I've lost count. I think he's got, I want to say around 50 active cases going. It's too much. All right, so we have an introduction here, a statement, and then the argument. Now, here's the key. We're going to talk about absolute immunity for the president encompasses all conduct within the scope of the president's office. So the question, the president is immune from civil damage claims for all conduct within the outer perimeter of his office. The district court correctly declined to adopt categorical limitations on presidential immunity. So again, this is off of the appeal. The appeal is what I'll be going through tomorrow, all right? So this is the appeal that the brief was written for. And they're going to talk about how the district court held correctly when they said there is not absolute immunity as the president. You do not have a full-blown absolute immunity, which is what everybody keeps saying with the Fitzgerald case. All right, so, and then next, and another piece I think is extremely helpful, is incitement of imminent private violence is not within the outer perimeter of the president's office. So we'll also talk a little bit about this issue of inciting violence and how that's not protected by the First Amendment. We'll get into that as well. So let me take you through here. 50. Yeah. Oh yeah, there's tons of cases still open and going. I mean, this is just 6 right here. Yeah, oh no, there's a ton. I try to hit the highlights of the biggest ones. I've known about this one for a long time, but I haven't really spoken about it. But now that, the motion to dismiss was filed in the DC case, I thought it was appropriate. Yep. All right. So here we go. Here's this. This is a great introduction as well. He's going to bolt. Possible. I mean, if it was me, I'd bolt. Are there 50-ish justice civil cases? No, I think overall, including all of the cases that are ongoing right now, and that's on the low end. There are so many open cases right now that he's involved in. It's a lot. All right, in these suits, members of Congress and Capitol Police officers have brought civil damage claims against former President Trump arising from injuries they sustained during the assault on the Capitol on January 6th. The United States respectfully responds to this court's request for its views regarding the former president's assertion of absolute immunity. To ensure that the president has the maximum ability to deal fearlessly and impartially with the duties of his office, the Supreme Court has held that the president must possess absolute immunity from damages liability predicated on his official acts, quoting the Nixon v. Fitzgerald case. That immunity reaches all of the president's conduct within the vast ambit of his office, including its innumerable constitutional, statutory, and historical dimensions. In many traditional spheres of presidential action, the president's responsibilities under Article 2 are extraordinary and far-reaching and damages claims predicated on conduct beyond the outer perimeter. Again, we're still quoting the Nixon case. Of those responsibilities are difficult to imagine in other contexts, such as when a president acts in his capacity as a candidate for re-election in a distinct campaign setting, that outer perimeter may be closer at hand. Even then, however, because the presidency is tied so tightly to the persona of its occupant, the line between official and personal is both elusive and difficult to discern. Citing this case here, in all contexts, questions of presidential immunity must be approached with the greatest sensitivity to the unremitting demands of the presidency. Nevertheless, although courts should be reluctant to conclude that a suit against the president is based on conduct that lies beyond the outer perimeter of his office, the United States agrees with the district court that a meaningful perimeter exists. So they're saying, yes, there are limitations. Nixon v. Fitzgerald establishes a rule of absolute immunity for the president's official actions. It is not a rule of absolute immunity for the president, regardless of the nature of his acts. Here, the district court concluded that plaintiffs' complaints plausibly allege that President Trump's speech at the rally on January 6th precipitated the ensuing attack on the Capitol, and in particular that the complaints plausibly allege that the former president's speech encouraged imminent private violent action and was likely to produce such action. The United States expresses no view on that conclusion or on the truth of the allegations in the plaintiff's complaints. That's what makes this an amicus brief, because they're not taking a side. But in the United States' view, such incitement of imminent private violence would not be within the outer perimeter of the office of the President of the United States. Right, so, and we'll move on with the continuing of the introduction. In this court, President Trump has not challenged the district court's conclusion, reiterated by the plaintiffs on appeal, that the complaints plausibly allege that his speech instigated the attack on the Capitol. Instead, his briefs advance only a single categorical argument. A president is always immune from any civil suits based on his speech on matters of public concern. All right, so does that sound familiar, everybody? This is exactly what he argued in his motion to dismiss. Exactly what he argued in D.C. All right, so any of his speech regarding public matters is protected, is what he's claiming. Even if that speech also constitutes incitement to imminent private violence, the United States respectfully submits that the court should reject that categorical argument. And because that is the only argument the former president has pressed on appeal, the court should affirm the district court's order on the narrow ground without attempting to comprehensively define the boundaries of the president's immunity for his speech on matters of public concern, including when and how to draw a line between the president's official and electoral speech. Those are sensitive questions of a fundamental importance to the executive branch, and this unusual case would be a poor vehicle for resolving them. Here's an endnote here, which I think is very important. The absolute immunity at issue in this appeal concerns only a president's liability in a private suit for damages. In addressing that question, the United States does not express any view regarding the potential criminal liability of any person for the events of January 6th. This amicus was filed before the indictments came out, just remember that, or acts connected with those events. The government also expresses no view on any other issue decided by the district court, including whether plaintiffs have stated a valid claim for relief under 42 U.S.C. 1985. This is the section of the code that you can sue someone who has deprived you of your constitutional rights or any other cause of action. Okay, so there we have our introduction. Here's a statement. Now, we're going to be giving some details of what happened, just kind of a broad overview of January 6th. So if anyone is sensitive about that information, I would recommend turning your volume off at this point. It's just a brief overview. Here's the statement. So following the events of January 6th, these lawsuits were filed by members of the House of Representatives and 2 Capitol Police officers. As relevant here, each plaintiff brought a claim against former President Trump under 42 U.S. Code 1985, which prohibits conspiring to impede officers of the United States in the discharge of their duties or to prevent any person from accepting a federal office. Some plaintiffs also asserted other claims against former President Trump, including claims under District of Columbia law. Plaintiff's central theory is that the former president and other defendants conspired to prevent members of Congress by force, intimidation, and threats from discharging their duties in connection with the certification of the Electoral College. Plaintiffs allege allegations against President Trump focus on his public statements following the November 2020 election, and in particular on his speech at the rally on the Ellipse on January 6th. Plaintiffs allege that President Trump's speech incited his supporters to commit imminent acts of violence and lawlessness at the Capitol. Number 2, President Trump moved to dismiss the claims against him, contending, as relevant here, that he's entitled to absolute immunity under Nixon v. Fitzgerald. He argued in particular that the primary acts for which plaintiffs sought to impose civil liability, his pre-January 6 statements and his speech at the January 6 rally, fell within the outer limits of 2 presidential functions. 1, the president's constitutional responsibility to take care that the laws are faithfully executed, and 2, the historical function of the office of the president as a bully pulpit to address and rally the public on matters of public concern. The district court rejected both arguments in relevant part. Okay, again, so I'm reminding you, this is very similar arguments that he put in his motion to dismiss in the D.C. criminal case. First, the court concluded that President Trump's challenged actions did not fall within his Take Care Clause duties because they were directed at implementation of constitutional and statutory provisions that do not prescribe a role for the president and are instead carried out by officials in state governments and in Congress. So this is the first point. It's not his role, all right? It's the role of the states and Congress. He did not have an obligation. Second, the district court concluded that the former president's actions did not fall within the president's traditional function of addressing the public on matters of public concern. The court recognized that speech is unquestionably a critical function of the presidency. It likewise agreed that President Trump's statements and speech addressed matters of public concern, the outcome of the 2020 election and election integrity. But the court rejected the former president's categorical argument that whenever and wherever a president speaks on a matter of public concern, he's immune from civil suit. In particular, the district court concluded that speech undertaken as part of a president's efforts to secure or perpetuate incumbency falls outside the president's duties because the office of the president has no preference for who occupies it. So this is really important. This is a really important holding out of the district court. All right. So the district court held the lower court. Part of the president's efforts to secure or perpetuate his incumbency, so part of his efforts regarding the election, fall outside of his duties because the office itself doesn't care who occupies it. I think that's absolutely genius how they stated that here. Yeah. Yeah, I agree. I agree. Who wrote this? Which side? This was written by on behalf of the United States. So they asked, let me show you the front page here. The Principal Deputy Assistant Attorney General wrote this. And again, it's on behalf of this question of presidential immunity. All right, so it's a brief for the United States as amicus curiae or amicus curiae. All right, so we'll keep this in mind. I think, again, this is going to be a really important point. Here, the court determined that the former president's challenge statements, including his January 6th speech, reflected an electoral purpose, not speech in furtherance of any official duty. So we have to make this distinction between an electoral purpose or an official duty. These are two separate things. If we're within the official duty, now we can talk about immunity questions under the Fitzgerald case. But if it's for an electoral purpose, it's not going to be covered. That's it. That's all it is. That's all there is to it. The court stated, for example, that the main thrust of the speech was to assert that perceived cases of election fraud had led President-elect Biden to win more votes in a closely contested states, to urge members of Congress to object to certain state certifications, and to exhort the vice president to return those certifications to those states to be recertified. After concluding that President Trump was not entitled to absolute immunity for the bulk of the claims asserted against him, the district court rejected other arguments in support of his motion to dismiss. So let's bump down to this end note. The district court upheld President Trump's assertion of immunity as to a claim that he violated 42 U.S.C. 1986 by failing to take action to halt the attack on the Capitol. So that's one point. Failure to act. They're saying he is not responsible for a failure to act. The district court did, all right? The court explained that the president cannot be held liable for an alleged failure to exercise his presidential powers. That's supported by case law. After concluding the president, hold on. The motion to dismiss. Sorry, I already read that sentence. As relevant here, the district court held that the former president's January 6th speech was not protected by the First Amendment because plaintiffs had adequately alleged that it constituted incitement to violence. So this is the number one thing that I just cannot say enough. This is another trigger for me, everybody. His speech was not covered by the First Amendment because if you are inciting lawlessness, you fail the Brandenburg test. All right? This is so important. So very important. So they said that they did show that. So his speech was not protected, the speech itself, under the First Amendment. Under Brandenburg, speech falls outside the First Amendment if it is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. That's the Brandenburg test. The court acknowledged that Brandenburg's imminence requirement is stringent, but it held that plaintiffs' complaints had plausibly argued that the former president's speech was an implicit call for imminent violence or lawlessness and was likely to produce a violent response from the assembled crowd. All right, so what's important here, we have a court holding that his speech was not protected by the First Amendment. All right, so keep that in mind. If anyone says his speech was protected by the First Amendment, well, not according to the district court out of DC. All right, they've already made that determination. Number 3, former President Trump appealed the district court's order denying absolute immunity. On December 20th, following briefing and oral arguments, the court invited the Department of Justice, which is who's writing this, to file an amicus brief expressing the views of the United States. So now we'll get into the arguments that they've set out here. Oops, there's my sticky note. So, the absolute immunity of the president encompasses all conduct within the scope of the president's office. to protect the autonomy and independence of the presidency, the Supreme Court has recognized that the president must possess absolute immunity from damages liability predicated on his official acts. That's the holding in the Fitzgerald case. That immunity extends to all presidential conduct falling within the innumerable constitutional, statutory, and historical dimensions of his office. The district court correctly refused to curtail that immunity into a category in the categorical ways that plaintiffs propose. So I'm going to pause again. So what they're saying is the Fitzgerald case says you are immune if you are doing one of your jobs that's written out for you by statute or the Constitution. So you have to actually be doing your job as president. That's when the immunity attaches. That's the key to the Fitzgerald case. All right? The president is immune from civil damages claims for all conduct within the outer perimeter of his office. Right? So we're quoting Nixon again. The Constitution vests the legislative and judicial powers in a plural Congress and plural judiciary, but it vests the entirety of the executive power in a single head in whose choice the whole nation has a part, making him the focus of public hopes and expectations. This exact quote is in his motion to dismiss. This is from the Youngstown Sheet and Tube versus Sawyer case in 1952. So this case is a historical case because it has to do with whether or not a president, through an executive order, could shut down the steel industry when they're striking. So they were striking and he said, you can't strike. And the court said, you can't do that. You have to let them strike. You're not in charge of private industries. So that's what this case is about. The Constitution entrusts the president with vast and unremitting public responsibilities, including taking care that the laws are faithfully executed, commanding the armed forces, nominating, appointing, and removing officers, making treaties, recommending, signing, and vetoing bills, sending and receiving ambassadors, and granting pardons and reprieves. We're quoting Article 2 here. And as the only person who alone composes a branch of the government. The president is called upon to speak and act not just for a single district or state, but for all the people of the United States. The sheer prominence of the president's office makes him an easily identifiable target for suits for civil damages. Again, another direct quote out of his motion to dismiss. A president must concern himself with matters likely to arouse the most intense feelings. Yet, as the Supreme Court has emphasized, it is precisely in such circumstances that there is the greatest public interest in providing the president with the maximum ability to deal fearlessly and impartially with his duties of office, to require the president to face private damages suits for actions associated with his office and role would threaten to make the president unduly cautious in the discharge of his official duties. So again, they're just quoting here how the scope of Fitzgerald. All right, so I'll bump down a little bit since we've kind of already gone through that. This immunity, the Supreme Court has explained, may not be curtailed by attempting to parse discrete presidential functions or through allegations that official acts were taken with improper motives, because the president has discretionary responsibilities in a broad variety of areas. In many cases, it would be difficult to determine which of the president's innumerable functions encompassed a particular action, and an inquiry into the president's motives to determine whether particular action was done in furtherance of legitimate function or for nefarious reasons would be a highly intrusive and would be impermissibly subject the president to trial on virtually every allegation that an action was unlawful. So they're just explaining here, again, that the Fitzgerald case applies to official functions that the president's supposed to do, and it's supposed to protect him from actually making official, comments. It's not about personal comments. It's about his duties as president. 652 students. Yes, thank you all for attending. All right, so here's B. So we've talked about the Fitzgerald case, all right? So Nixon v. Fitzgerald, we've talked about it. There is an immunity when it includes an official job set out in the Constitution, which they went through and gave examples of, like pardons, all right? The district court correctly declined to adopt categorical limitations of the president's immunity. The district court correctly declined plaintiff's invitation to carve out certain areas of presidential conduct as categorically beyond the outer limits of the president's office. First, the district court correctly declined to embrace plaintiff's suggestion that presidential speech or conduct necessarily falls beyond the outer perimeter of the president's office if it concerns functions that the Constitution assigns exclusively to another branch. Plaintiffs renew that contention in this court, urging that any conduct by the president concerning the certification of presidential election results necessarily falls outside the immunity recognized in Nixon because the Constitution and relevant statutes afford the president no role in the certification process. So let's pause here. All right, let's pause. So this whole question about the certification of the electors is not up to the president. The president has no role and then therefore cannot have any immunity for what he's done because of that. The categorical claim disregards the complexities of the presidential role in our constitutional system. Although the Constitution allocates powers among the three branches, it also contemplates that the branches will check each other in the exercise of those powers. History teaches that in many circumstances, such inter-branch checks occur through officials' use of political, public, and interpersonal power rather than through the exercise of any enumerated constitutional authority. So we're citing the NLRB case. Thus, for example, a president acts within the scope of his office when he urges members of Congress to act in a particular way with respect to a given legislative matter, even a matter such as congressional investigation, in which the president has no constitutional role. That is particularly plain with respect to the damages claims predicated on president's speech to the public. The president of the United States possesses an extraordinary power to speak to his fellow citizens and on their behalf. The immunity recognized in Nixon thus ordinarily protects the president from civil damages liability arising out of his speech to the public on matters of public concern. Again, this is the key. Plaintiffs rightly do not dispute that. For example, a president's speech about military or foreign affairs matters or about the actions of the executive branch falls within the outer perimeter of his office. What makes this case different, they argue, is that President Trump's speech was directed towards the constitutional responsibilities of another branch of government. True. The traditional bully pulpit of the presidency, however, is not limited to speech concerning matters for which the president himself bears constitutional or statutory responsibility. The public looks to the president as the leader of the nation for guidance and reassurance, even on matters over which the executive branch or federal government as a whole has no direct control. From the actions of Congress and the judiciary to the policies of state and local governments to the conduct of private corporations and individuals, the president can and must engage with the public on matters of public concern. And this is the key. Such speech is an important traditional function of the presidency, and it would offend the constitutional separation of power principles recognized in Nixon for courts to superintend the president's speech to his constituents and to other office holders by entertaining civil damages suits arising out of that speech merely because it concerns the conduct of a coordinate branch or an entity outside of the federal government. So they're saying just because he's talking about jobs that the other branches are doing doesn't necessarily mean damages need to be awarded. Second, the district court correctly rejected plaintiff's contention that any conduct occurring in the context of a political campaign necessarily falls beyond the outer limits. So they're going through the other argument that they did not agree with the plaintiffs on. The United States agrees with the district court that the office of the president has no preference for who occupies it, and that Article 2 is agnostic as to whether a sitting president is elected to a new term. A president's private partisan electioneering activities lacking any significant nexus to his responsibilities as president may therefore fall beyond the outer limits of his office under Nixon. All right, so there's another key piece. All right, everybody, so campaigning falls outside of your duties as president. So we don't even have to deal with, we had talked before about the Hatch Act, where federal employees are not allowed to campaign for president. the president's not covered by the Hatch Act, but other federal employees are. But the district court here and the Department of Justice here explains the president campaigning is outside of his responsibilities as president. All right, that's kind of an essential holding here. So let's highlight that. That's very important. Right. The principle, however, must be understood and applied with the greatest sensitivity to the complex and unremitting nature of the president's role, office, and role, which are not amenable to neat dichotomies. The Supreme Court has emphasized, for example, that there's not always a clear line between the president's personal and official affairs. That is especially so with respect to the president's speech to the public. As the district court observed, a first-term president is, in a sense, always a candidate for office, and it is not the least bit unusual for first-term presidents to comment on public policy or foreign affairs at campaign events, or in this state, to announce policy changes by tweet during an election year. The announcement of a presidential, flipping the page, policy decision at a political rally or remarks on foreign policy delivered at a campaign event cannot categorically be excluded from the scope of the president's office merely because of the context in which they are made. And other statements at such events may be understood by members of the public and domestic and foreign leaders as reflecting the official views of the president, not just the remarks of a political candidate. So what they're saying here is that it's complicated. There's no bright line rule here, but it's complicated. Nor is it appropriate to frame the immunity question, as even the district court appeared to do at times, in terms of whether the challenged conduct of the president was undertaken with a purpose to secure or perpetuate incumbency. The president is both the chief executive and elected politician. His policy decisions are also political acts with political consequences. The Supreme Court in Nixon emphatically rejected an argument that otherwise official acts lose immunity if they're motivated by an impermissible purpose. That logic applies with even greater force to the suggestion that the president should be subject to suit for his official acts whenever those acts are plausibly alleged to have been motivated by electoral or political considerations. So that's part 3. Part 4. Incitement of imminent private violence is not within the outer perimeter of the president's office. So let me just kind of summarize what they're talking about here. The first argument about speech was saying he was talking about other branches of government. That's not protected. The Department of Justice is saying, we're not sure about that. We're not sure that it's actually excluded. Then they're saying, well, it's political speech because he's campaigning. And the Department of Justice is saying, I'm not really sure that that's also not included as, immune. But when we start talking about the language that's inciting violence, now we will get into how the speech was not protected and immunity does not apply. All right? Here we go. Incitement of imminent private violence is not within the outer perimeter of the president's office. District Court also correctly rejected President Trump's categorical assertion that whenever and wherever a president speaks on a matter of public concern, he's immune from civil suit, even if that speech also constitutes incitement to imminent private violence. Speaking to the public on matters of public concern is a traditional function of the presidency. The outer perimeter of the president's office includes a vast realm of such speech, but that traditional function is one of public communication. It does not include incitement of imminent private violence of the sort the district court found the plaintiff's complaints have plausibly alleged here. That's the key to this case, all right? So the language he used is not covered because it's asking for violence. It's inciting violence. Do hydrate. Oh, yes. Yes, I will. Thank you for the reminder. All right, we're coming down to the finish line. All right, so let's, all right. All right, here we go. Let's bump down to the footnote. The district court correctly dismissed the claim alleging that President Trump improperly failed to exercise his official powers to stop. Again, so this footnote is saying he did not have an obligation as the president to tell people to stop. All right, and that goes with case law as well. The United States here expresses no view on the district court's conclusion that plaintiffs have plausibly alleged that President Trump's speech incited the subsequent attack on the Capitol. But because actual incitement would be unprotected by absolute immunity, even if it came in the context of a speech on matters of public concern, the court should reject the categorical argument President Trump pressed below and renews on appeal. Resolving the appeal on the narrow basis would allow the court to avoid comprehensively defining the scope of the president's immunity for speech to the public, including when and how to draw a line between a president's speech in his presidential capacity and speech in his capacity as a candidate for office. All right. So we'll stop there with this analysis because we have that conclusion now. So when we're looking at the Nixon Fitzgerald case, there is immunity only within your official powers, right? Or even the outer perimeters of your official powers. But what they're saying here is language inciting violence is not part of the president's official powers, and therefore immunity is not applicable in those situations. All right, so they continue to go on with more of that. So there may be circumstances in which a president acts purely in his private capacity as a candidate for office, even though he's speaking to the public about matters of public concern. But as explained above, drawing a principal and judicially administrable line between the president's official and electoral speech would pose sensitive and difficult questions. The United States respectfully submits that this is an unusual case and would be a poor vehicle, again, to answer those questions. Every president engages in a wide array of speech that could be characterized as electoral. So the contours of immunity in this context are of great importance to the presidency in the future and to future presidents. In the government view, any decision about how to define the limits of absolute immunity in campaign context should await a case in which the relevant issues have been fully briefed and it is necessary to decide them. So that's their conclusion. All right, the district court's denial of absolute immunity should be affirmed. So there you have it. There is the analysis. All right. We've got this question again under the Fitzgerald case. Is there absolute immunity? The answer is there is immunity as long as it is an official job, and using language inciting violence is not within the president's job description. It's pretty significant. I think this is pretty significant. Now, again, this brief was submitted as part of the appeal for the case where the officers and representatives were suing. And again, I will go through this case in detail tomorrow. This is the actual decision again, and I'll be summarizing this, not going line by line here, but the court does go into immunity and does uphold the district court's decision again that there is no absolute immunity under the Fitzgerald case, and does talk about how this language was inciting language, it incited violence, and is not protected. Yes. So I think that's a pretty big issue here that has been discussed multiple times. So I think that they did a pretty good job kind of taking a look at that Fitzgerald case and kind of making sure that the immunity set out in Fitzgerald wasn't overshadowed. So lots of, it's a difficult situation, but also it shows that the motion to dismiss out of DC is just a pile of bologna sandwiches. Also, did you notice the citations? The citations in this case are so nice. It was such a treat to see proper citations, unlike previously. So, we actually have proper citations here, which was nice. So I appreciate that. I thank you kindly for that, Department of Justice. Oh, my goodness. Yeah, thanks goodness it's documented correctly. I agree. So, all right, well, that's really it. That's what I've got for everybody for tonight. Had that update then on the Florida case and kind of questions about why the judge is kind of dragging her feet. And then also this question of absolute immunity out of the Nixon v. Fitzgerald case, which, you know, is a triggering case for me. No, there is no absolute immunity, but I think that they discussed that pretty good. So this case was a really nice vehicle to talk about that. But tomorrow I will go through the lawsuits then that are still open against Trump regarding damages done that day. Why is the judge dragging her feet? I'm not sure why. I'm uncertain exactly. I'm not sure if this is just how she runs her court, or if, you know, it's kind of an intentional situation. So I really don't know. So appreciate your time you spend with us. Oh yeah, of course. They will claim immunity every time. They really will, and you will hear it repeatedly. You will hear this argument over and over and over again, and you're going to hear it more in the next week or so. So I thought, you know what? It's good for you to know where the case came and how it's being applied. Oh, sure. You're welcome. The Monkeys in the Wizard of Oz. Yeah, it's frustrating. It's extremely frustrating, especially when the law isn't being applied correctly. And, you know, I mean, as the judge in New York said, what? What are you doing? Sanctions? Everybody's getting sanctioned. Thank you so much. And the chat, this is always informative. Yes, of course. Oh, I've got just the best people in the chat, the best moderators. So thankful for everyone's time. So hopefully everybody kind of got some new information with regards to the immunity situation. Do you think any of his claims of immunity will be successful? No. No, I do not. Thank you for your time. Oh, you're welcome. Yes. Thank you. Thank you for coming. I appreciate it. Thanks for spending time with me, everybody. Love being able to say I've read the court documents. Yes. Well, yeah, you have. They're all available online too if you want to go back through. Learning so much. Yes, I'm glad to hear it. Love the nails. I see you. Thank you. Yeah, these are my pre-Halloween nails. I've got plans. We're going to be busy this next week or so, everyone. So before I officially sign off, let me give you again the overview of our calendar so we kind of know what's going on. Because it's madness, everybody. Oh, thanks for the crown. Thank you. So here we go. It's madness. It's madness. We have coming up. So just so you know, I have my own live schedule. This is my live schedule that I'm hoping to stick to over the next few days. Thank you so much. Yes, you're welcome. So tomorrow I will be doing the Georgia update at 6 p.m. So we've got new orders that came out in Georgia yesterday. So I'll be going through that. That'll be 6 p.m. In the morning, I will be going through the civil lawsuits against Trump regarding the officers in D.C. during the speech. That'll be in the morning, 10 o'clock. Then on Monday, I will be reviewing the civil case out of New York. Tuesday, I've got the criminal case out of New York that, you know, we haven't really been talking much about, but I think it's worth spending a little bit of time on it. Nearly 2 a.m. Yes, good night, Deborah. Always a pleasure to see you. Wednesday, I've got stuff, so I won't be here. But then Thursday, we'll do another Florida update. And then I'm going to start doing my Fridays, just doing a weekly review of where the status is for all of the cases. So that's my schedule for next week for anyone who is interested. I will be doing 10 a.m. tomorrow, but other than that, it'll probably be 6 p.m. Central Time for the rest of the week. I may pop in do a morning one, but I can't guarantee it. It's just my voice is not what I want it to be in the morning. So yes, and I'm one video behind. I did post yesterday morning's live already on YouTube. That is up. But last night's live is the next one that will go up, and then this one. So I've got two in the bin, and then we'll be going. Such a gift to us in our democracy. Oh, you're welcome, Chelsea. You're welcome. I'm glad it's helpful. Hopefully, you can get some insight and not feel so adrift because so much is going on. I think one of the most stressful things is when so much is going on and you have no idea what it means. So Happy to help, everybody. Happy to help. I will be back again. Love this. And oh, thank you so much, Frank. Yeah, absolutely. I'll be having some tea. Some tea later. Yes, it's the same name as my as my TikTok account. So I will be back again 10 a.m. tomorrow, everybody. Thank you again for your time and your questions. Always a pleasure. I'll go ahead and sign off for tonight. Again, thank you so much, everyone. Take care, and I will be back again in the morning. So have a great night, everybody.